Hello, everyone. Today I'm going to discuss the thought of infliction of mental suffering. While we usually associate tort claims with harm to people or property, the law also recognizes emotional or psychological harm as a distinct injury. It recognizes that certain kinds of behavior under specific conditions can be deeply offensive and psychologically damaging to other people, even if there is no threat of physical harm. The thought of infliction of mental suffering was created to guard against this kind of emotional abuse by allowing the victim of emotional suffering to be able to receive compensation from the wrongdoers. Infliction of mental suffering occurs when a person, through extreme or outrageous behavior, intentionally or recklessly causes severe emotional distress, mental trauma, and/or bodily harm to another. In some situations, this mental suffering may be caused through negligent conduct. The threshold to prove this tort is higher in situations where the harm is caused through negligent conduct. You need to show that the harm was foreseeable, than in cases of reckless infliction of emotional suffering. Generally, this tort is very difficult to prove since in most instances it may require extreme medical evaluation or assessment to establish the extent of the harm, but also in terms of connecting the mental or psychological harm to the act of the defendant. The key elements of this tort are as follows. There has to be an intentional or reckless act by the defendant. That act must depict extreme and outrageous conduct. And here I invite you to look at the case of Wilkinson versus Downton, where a customer at a pub decided to play a prank on the pub owner's wife. He told the wife that her husband had been involved in a terrible accident and had broken both legs. As a result of this prank, the pub owner's wife vomited and suffered a violent shock to her nervous system, leading to weeks of suffering and incapacity, which required medical treatment. It was deemed in this case that um, the act of downtown was really very outrageous and extreme. It is not something that you would envisage people could do to others in a civilized society. So the pub owner's wife recovered in that case. The third ingredient is that severe and mental suffering has to be occasioned on the plaintiff. Severe and mental suffering has to be occasioned on the plaintiff. And here we are not talking about minimal psychological disturbances. We're talking about something that can be medically categorized as being severe. So it's not any kind of distress. It must be severe distress. There is emphasis on that word. And then the last element is that it has to be proven that the defendant act is the cause of this severe mental suffering that the plaintiff is going through. Under this tort of infliction of mental suffering, nervous shock or psychiatric harm is a medically recognized condition of a sustained nature. In other words, it's just not a one-off. It has to be of a sustained nature that disturbs the normal functioning of the mind. It might or might not be accompanied by overt symptoms. In other words, you don't have to demonstrate physical harm in regard to this particular tort. It's enough that someone suffers severe psychological trauma. In the case of Delio versus White, the plaintiff who was pregnant was walking behind the bar when the defendant's servant negligently drove a van into a public house. The plaintiff suffered shock, which resulted in the premature birth of her child, and she was able to sue successfully. So you can see that in that case, we see the nervous shock that's occasioned on this lady, but again, it goes beyond the nervous shock. There is a kind of physical act which results in her prematurely giving birth to the baby. I also invite you to look at the case of Hamburg versus Stokes Brothers. It's 1925, Volume 1, King's Bench at page 141. In discussing this tort, it's essential to make a distinction between primary and secondary victims. A primary victim is someone who has been directly involved in the distressing events, while a secondary victim is someone who has witnessed the distressing events but has not been directly involved. You can again look at the case of Dury versus White. Also in the case of Page versus Smith, where the House of Lords decided that as long as personal injury harm, whether this is physical or mental, is reasonably foreseeable, then a primary victim could succeed in a shock claim. Also look at the case of McLaurin versus O'Brien. Where it was stated that a defendant who is under a duty of care to the claimant, whether as a primary or secondary victim, is not liable for damages for nervous shock unless the shock results in some recognized psychiatric illness. So here they are again emphasizing the gravity of the suffering that needs to happen before a defendant would found an action on this tort. It has to be severe, it has to be sustained, and there has to be a result that this person has suffered a psychiatric ailment or a nervous breakdown. In Jones versus Wright, the court attempted to determine the issue as to whether the defendant owed the plaintiffs, who are secondary victims, in this case, a duty of care. And two issues were brought out as being very pertinent in determining whether a secondary victim should recover. First is the degree that victim has in terms of the relationship between the plaintiff and the person in danger. In other words, they're trying to say you don't just randomly recover because you've witnessed, for example, an accident occurring in regard to a third party. You must have a relationship with this person for you to be able to find the nervous shock you suffered as a result of witnessing the events and categorize it as an infliction of mental suffering. Then the second question is the proximity. How far are you to the accident? For example, can you recover if you just watch an accident on a live streaming of a television? Should you be present if you come after the accident has occurred? Should you actually recover? So it's critical to also determine how close you are geographically when these distressing events occurred. In the case of Alcock versus Chief Constable of the South Yorkshire Police, the court laid down the following requirements in regard to secondary victims. And the court stated that it has to be demonstrated that there is a sufficiently close relationship of love and affection with the primary victim to make it reasonably foreseeable that the plaintiff must suffer nervous shock if they apprehend that the primary victim had been injured or might be injured. And then the second requirement that was laid down again as in the case we discussed before, regards to proximity to the accident or its immediate aftermath. And here they kind of extend it to the immediate aftermath, and they say that this has to be sufficiently close in terms of time and space. I invite you to look also at the case of James versus Coffey. In that case, Mrs. Coffey's husband was seriously injured by the negligent driving of James. After seeing her husband in hospital with all these tubes coming out of him, and after being told that he may not make it, Mrs. Coffey suffered a nervous shock. She sued and succeeded. So the point here is that she wasn't present when the accident happened, but when she came and saw her husband in hospital, she suffered shock. So in other words, this case attempts to extend the doctrine beyond who actually sees the event to those that also perceive its direct aftermath. So here she wasn't present, but then she came and then saw the aftermath of the accident. So she should be able to recover. You can also look at the cases of Bonhill versus Young and Vernon versus Bosley. In both these cases, the claim for infliction of mental suffering was rejected, and the courts argued that the threshold was not met. For example, if I hear an accident, a bang happening, and then as a result of the bang, I suffer nervous shock, should I recover when I've not seen? So look at those two cases to be able to make a distinction in regard to situations where a plaintiff may recover in a case of infliction of mental suffering. The last point to make here is in regard to infliction of mental suffering, it's critical that you take the victim as you find them. So if you indulge in a reckless, intentional, outrageous act, and then a lady, for example, suffers a nervous breakdown, but previously this lady had bouts of nervous breakdown, and you can't argue that she was already exhibiting some of these signs. The important thing is, has your act actually aggravated the situation of this lady? And in that regard, I invite you to look at the case of Bryce versus Brown, 1984, Volume 1, All England Reports. Thank you very much for listening to me.